first of all, if you take into consideration the earlier act, the earlier amendment, which is now the act, that basically has the major amendments. They have made a large amount of amendments in the NAB laws, the National Accountability Bureau Ordinance. If I can just give you a brief of that, and then move on to the recent one, which has not been granted the assent by the president yet, and on the 22nd, I believe they are going to take it to the joint session and have it passed from the joint session. And obviously, then again, it goes to the president. And if president fails to grant the assent, it becomes operative and becomes the act of the parliament. So I'll start off with the first amendment, which is now the act, the Amendment Act, the National Accountability Bureau Ordinance, Amendment Act 2022. That which has the major amendments. The first very interesting bit to note in that is that they have given a retrospective effect to all the amendments. First of all, they have said that these amendments should come into force at once and be effective and be given effect from the date of 1999, when the actual National Accountability Ordinance 1999 was passed. So which will affect, which means that it will affect directly the pending pending trials in the courts, the inquiries, investigations, and the pending cases, the proceedings pending all over Pakistan in the accountability courts. The other, for example, the major amendment that they've made, actually to start with, the first amendment that they've made in the ordinance is that they've said that the following persons and the transactions are excluded from the jurisdiction of NAB. And then they start off by saying persons and transactions which are to be excluded from NAB jurisdiction are, for example, the taxation matters of federal and provincial or local governments. Those will not fall within the jurisdiction of NAB. The other one is the decisions made by the cabinet, the committees, subcommittees, the Council of Common Interest, and also by the regulatory authorities, the bodies, and the State Bank of Pakistan, and so on and so forth. So all the decisions are made by those authorities will not fall under the domain of NAB anymore. Then they go on to say that any transaction which is made, which is not is made by a person which is not directly or indirectly connected to a public office holder, cannot be inquired and investigated. So basically, any person which is not directly or indirectly linked with a public office holder, a private person, a purely private person, cannot be inquired under the NAB laws anymore. So private person is excluded from it. Then obviously because they've secured the cheating of public at large, but in that case also they've given a minimum number that there has to be more than 100 people. There has to be at least 100 people who have complained of cheating for it to fall within the bracket of cheating of public at large. And further, that moving on, they've also said that the procedural lapses by the officials working in the government organizations or authorities controlled by the government, for example, any public office holder. So any procedural lapses will not be inquired into and would not fall under the jurisdiction of NAB unless there is some monetary gain on their part. Then they talk about the misuse of authority. They've again redefined misuse of authority. They say that misuse of authority by any official or public office holder cannot be inquired into, cannot be investigated unless there is evidence to the fact that that person, while exercising his official duty, has made some monetary gains. There is some ill-gotten gain on his part for him to fall under the jurisdiction or for him to be investigated under the NAB laws. Then they have also said, which is just a two-line amendment, but is a very, very long, it has a very broad meaning. I would say it's a gray area, where they say that all matters which are decided or fall within the jurisdiction of regulatory authorities cannot be looked into by NAB. So all the decisions or matters which fall under, say, PEMRA, OGRA, PEPRA, say any regulatory authority. There are like tons and tons of regulatory authorities which have their own laws, the separate laws for say for example, the Cooperative Societies Act, for example. So there's so many laws of the regulatory authorities um, established under the provincial or federal laws. They have their own scheme of law mechanism to investigate, interrogate, and prosecute, etc. So they say, so the new amendment now says in the NAB ordinance, which has been made, is now that they cannot be investigated by NAB anymore. They all have to, in fact, all the pending cases also, be it the inquiries, investigations, or the references pending before the accountability courts, will have to be transferred back to those particular regulatory authorities. So matters pertaining to OGRA will go back to OGRA. Matters pertaining to PEMRA, for example, will go back to PEMRA, and so on and so forth. So I would say the jurisdiction of NAB has been curtailed to a large extent. Then I will they take you to the next amendment. For example, they defined the term Benamidar. So now they say Benamidar is someone who is uh, holding the property for the benefit of the accused person. The accused person is in possession of that property. The accused person holds the title documents of that particular property, and unless there is evidence that the money was paid for that property went from the accused person, that cannot be termed as Benami transaction or a Benami dar or a Benami property. So there also the law has been amended, which I believe is already established. Benami has a certain a few what's it called characteristics. For example, as to who paid the money for the actual property, who is in possession of the property, who has the title documents, who has been paying their taxes, the way in which the property is being dealt with, so on and so forth, which shows if it's a Benami property or Benami transaction or not. So then they have also amended the provision in the law regarding the appointment of chairman NAB. So it used to be the president of Pakistan who would initiate in consultation with the leader of the House and the leader of the opposition. Now it's the federal government doing it in consultation with the leader of the House and the leader of the opposition. And then the whole mechanism is given as to how, if a consensus to a name is not reached, two names will be given each by the leader of the House and the leader of the opposition, and how it's going to be sent to parliamentary committee, what's going to be the strength of the parliamentary committee, how many 50% members in the parliamentary committee are going to be from the treasury benches, 50% of the members are going to be from the opposition benches. If the National Assembly is not in place, it has been dissolved, then all the members are to be taken from the Senate. Otherwise, 25% of the members have to be from the Senate. So that's another detailed amendment that has been made in the law. The other thing is, the other amendment that has been made in the law is also that they've amended Section 9, which was one of the most important provisions in the NAB ordinance, which provided of the corruption and corrupt practices, the definition of corruption and corrupt practices, the instances, and what the categories of corruption and corrupt practices. So in that section also, certain amendments have been made. Then they have said, mainly they've said that there has to be some monetary gain, there has to be some ill-gotten gain on part of the official that is accused of misuse of authority. And then they've also said about in the asset beyond, for example, in the asset beyond means cases, which was always a very, very easy tool for the prosecution to prosecute anyone, because it was a very, very large area, a very wide scope, wide authority with no, NAB and the chairman to initiate any inquiry against any on the basis that his known source of income and his was not and his assets were disproportionate to his known source of income. So now they have the changes that they've made there are that, for example, they've defined the valuation of the immovable property. So they've said that the valuation of the immovable property has to be taken and from the title document itself, the amount disclosed in the sale deed or the lease deed, for example, or the DC rate, the collectorate rate, or the FBR. The FBR valuation fixed by the FBR, whichever is higher. So they cannot, allege or uh, uh, prosecute on the basis of market value anymore. Usually, the investigation officers, in a large number of cases that I've also dealt with, we noticed and we took, we always would take a defense in the courts, in the accountability courts, that the amounts which have been alleged by the investigation officer and the references or the investigations are the market values, and also the market values of the time when the case was being filed or investigated, not of the time when the property was actually acquired and purchased, which was largely unfair on part of the prosecution, because a property which was, for example, purchased for 1 million rupees 10 years ago and today was 100 million rupees, they would allege and prosecute on the basis of the current market value of that day. So that has been taken out, and there is no room for the investigation officer to do that anymore. So he has to take one of the valuations either from the title document, or from the collected value, or thirdly from the FBR value. Thirdly, they've also, moving on, they've also made a amendment in the. They've also said that all transactions, the credit transactions that they've made in the credit transactions that have been made in the bank accounts cannot be termed as movable assets, unless there is corresponding evidence that they come from a corrupt practice, etc. So any money coming into an account cannot be treated as movable asset and cannot be questioned. And then the main amendment that has been made in the NAB law is the curtailment of the arrest powers, of the powers of the arrest, which the chairman used to enjoy. So the chairman NAB had large amount of powers to the regarding the arrest, and he could arrest on literally anything. And he just had to issue a arrest warrant on application of the investigation officer, and the IO was free to arrest that accused person being inquired or investigated. However, now what they've done is that they've completely taken out the merits of the case. So the chairman NAB has to the chairman NAB can only issue arrest warrants on the following four grounds. One being that this person is a flight risk. If he is going to abscond, that was one ground. If they feel if that the accused person will abscond or is a flight risk, that's when the chairman will issue the arrest warrant. Number two, if they have credible information that he's a habitual offender, he's going to repeat the offense and continue with the same offense. That's when he can issue the arrest warrant. And thirdly, it was that he's going to temper with the prosecution evidence. So again, if they feel that the accused person is going to manage the prosecution witnesses or temper with the prosecution evidence, that's when the chairman NAB can issue the arrest warrants. Fourthly, it was that the accused person is not willing to join or is avoiding to join the investigation. So on these, now it is only on these four grounds and only these four grounds that the chairman NAB can issue arrest warrants for arrest of any accused person. Other than that, he cannot issue arrest warrant. It's just like it happens in the West, for example, in the UK. So no matter how heinous of a crime you're faced with, you are usually granted bail. First of all, you're not arrested, or if you're arrested, you're granted bail on these four grounds, without looking into the merits of the case, without going into the facts and the allegation, without having to hear the defense from the accused person. So these are the major changes that have been made. There are some other changes that might be worth mentioning, is that, for example, any inquiry or investigation against a financial institution cannot be made unless there is permission of the governor of the state bank. So you need permission of the governor of the state bank to investigate any financial institution for any financial crime, which has to do with any financial institution or a bank. And also, the other interesting amendment is that the documents received from a foreign country, will not be treated as evidence. So any evidence that has been coming from the foreign country will not be treated as evidence and cannot be allowed to be produced as evidence. Also, the remand, authority of court has been curtailed to 14 days. Sorry, I apologize. 14 days from, as opposed to 90 days. Initially, it was 90 days. Up to 90 days, the NAB could seek remand, and the court concerned would give remand of 15 days each every time. And now it is maximum 14 days of remand as opposed to 90 days. So more than 14 days of physical remand cannot be given of any accused person to NAB. I think it's going to affect the investigation rate already, because the prosecution was so poor. The quality and standard of prosecution in this country is terribly low, especially when it comes to NAB. If you compare the prosecution and the quality of investigation conducted by NAB officials, it is even worse than our police authorities. I would say our police investigation at times is far better than the NAB authorities. And if you compare, for example, the prosecution or the investigation of FIA as compared to NAB, there is a difference of day and night. FIA is much more superior. So NAB, having all the authority, power, the resources, everything, the quality and standard of investigation was extremely poor already, and the rate of conviction was the reason for the rate of conviction being so low was because of their poor investigation and prosecution. And after these amendments, I think I think, in my humble opinion, the conviction rate will even go further down. About the plea bargain, they've also made a small amendment in this, which was already, actually, to be honest, was already authored by a lot of superior courts of Pakistan, including the Supreme Court and the High Courts, which said that the acceptance or entering into a plea bargain of one accused would not have any impact on the other accused persons. So in an offense, or in a case where there are 10 accused persons and one of them admits his guilt, basically plea bargain is a conviction. Plea bargain is not that you were acquitted. Plea bargain means you are convicted. The only thing is that you don't get a jail sentence. You don't go to jail. You are debarred from holding a public office for 10 years. You're debarred from obtaining any financial facility, any loan for 10 years. You obviously have to disclose everywhere that you're convicted, because it is actually a conviction. People have this misconception that plea bargain is like anyone would just come and offer, for example, the allegation against him is of $100 and he's offering $20 and he's walking out free. It's not like that, to be honest. Plea bargain application was to be moved from the investigation officer to the chairman, and the chairman, in most circumstances that I've seen, because I've been regularly appearing in a lot of NAB cases, before the accountability courts or the high courts in bail matters or the trials. I have noticed that plea bargain had actually recovered a lot of money, had recovered a lot of money, and through plea bargain, the downside, the consequences or the repercussions of the plea bargain, I've already told you. I've already mentioned that they cannot hold a public office for 10 years, they cannot obtain any financial facility, and they deem to be convicted from that day onwards, and they're not. um they're not free to go. So they only just don't get the jail sentence. Well, I think it's going to make a big difference because the case that has been filed, I believe, by PTI, in the Supreme Court, that petition, or the grounds that they've taken, one of the major grounds I would say that they've taken is that this law is self-serving. uh, Most of the people who have passed this law, the parliamentarians or the ruling parties, are facing prosecution themselves, and therefore this law is person specific or to benefit their own selves, their own and and because it is person specific, it cannot sustain, and it is to be struck down by the courts. And because there's established law that no law can be person specific. Person specific does not mean that it has to be only concerning one particular person. It can be any class of persons. So PTI probably would argue that at least one of the arguments would be that this is benefiting the rural party and the parliamentarians who are in the government right now, because most of them are on bail and facing prosecution, and therefore this law should be struck down, and it is against the public interest also. But I feel, let's see what happens in the Supreme Court. The Supreme Court has to strike a balance, because in the past you've seen the economy actually suffered because of the poor investigation. There were a lot of people who faced tremendous amount of torture and trauma because of NAB officials. A lot of private persons, a lot of builders, a lot of private persons who've never held any public offices had to suffer. Even the public office holders, a lot of bureaucrats had to suffer, or even say politicians had to suffer a lot of trauma and torture and harassment to a large extent. And in the end, you see most of them walk out clean, and they are acquitted from the courts, be it because of lack of evidence, be it because of poor investigation, be it because of poor prosecution. The major issue with NAB is, in my humble opinion, as a professional, as a lawyer, as a lawyer who's been appearing for the defense side for a lot, for over a decade, even at the time of PTI's government, the basic thing that they could have done at that time was improve the prosecution and the quality and standard of investigation, which was largely ignored and not spoken of at all, to be honest. And that was the reason NAB's performance was highly affected. But you see, it was the courts which would always, a lot of times the court would see that there are a lot of flaws in the prosecution and the investigation, and on the basis of the settled law, the earlier precedents, we will have to grant bail, even though they could tell from the allegations of the case that this person, for example, is involved, and we can smell fishiness, or we can tell from the case that he's involved, and the case is made out against him. But because there's so many flaws and defects in the prosecution and the material, the evidence that is being collected, or the evidence produced in the court by the witnesses, they had to acquit them, or they had to grant them bails. So I think I think it's going to these amendments are going to make a big difference, a huge difference, because obviously PTI wanted to pressurize the current government and the parliamentarians and their leaders through NAB, which cannot be done, I think, anymore, because as I already have mentioned, that the powers of the arrest have been largely curtailed. So the chairman now can only issue warrants in those four circumstances.